Your access to the spring is unauthorized. You have 14 days to cease all activity in that area, or we will pursue enforcement action. She said it the way people say things they have rehearsed, evenly, with a slight forward lean, as if the posture alone conferred authority. She was standing at the edge of my gravel drive in a blazer the color of slate, a laminated badge clipped to her lapel, a tablet tucked under one arm like a prop she had forgotten to use. Behind her, a white SUV sat idling in the afternoon heat. I looked at her. I looked at the letter she had extended toward me, crisp and official, in a manila envelope with the Clearwater Ridge Community Association seal embossed in the upper left corner. I took the envelope. I thanked her for coming. She had no idea. That is the part that still strikes me, standing here now, looking out at the same ridge she was gesturing toward when she delivered that line. She had no idea that the spring she was referencing, the access road she had driven in on, the 40-acre parcel where the association's maintenance facility sat, all of it was on my land. 5,100 acres deeded to my family before the association existed, before the subdivision existed, before anyone had drawn a single line on a plat map for Clearwater Ridge. I had inherited every acre of it. And I had not yet told anyone what I was beginning to find out about what they had been doing with it. Drop a comment and tell me where you're from. If something like this has ever happened to you, I want to hear it. My name is Elias Voss. I am a civil engineer by training and a farmer by disposition, and I have spent most of my adult life working land in the high desert of eastern Oregon, where the soil is the color of old rust and the mornings come in cold even in July. The spring is on the western edge of the property, where the elevation drops and the basalt shelf gives way to a seam of limestone that has been pushing water to the surface for as long as anyone in my family can remember. My grandfather, August Voss, called it the patient spring. He said it was because the water did not hurry. It moved at exactly the rate the earth allowed, and it had been doing so since before any of us arrived and would continue long after. He was a man who respected things that did not hurry. August acquired the original parcel in 1947, 3,000 acres of high desert range purchased from a ranching family that had overextended itself during the war years. He paid cash, which was the only currency he trusted, and he recorded the deed at the county seat in Vail the same afternoon he signed it. Over the following 2 decades, he added to the property in careful increments. 600 acres to the north in 1953, another 400 along the Spring Corridor in 1961, and a final 600 in 1968 that brought the total to just over 4,500 acres. My father, Thomas Voss, acquired the remaining 600 and change in 1979, consolidating the boundary along the western ridge, and it was his name on the deed when he died, along with mine, added in a joint tenancy amendment filed in Malheur County in 2004. When my father passed in the spring of the year I turned 51, the land came to me entire, 5,112 acres, more or less, as the deed read. More or less. I had always found that phrase quietly funny, as if the county recorder was acknowledging that land has a way of exceeding the numbers assigned to it. I grew up on the property the way children grow up on land that has been in a family long enough to feel like a member of it, not as a possession, but as a presence. I knew where the spring ran cold even in August, where the deer crossed the lower fence line before dawn, where the soil changed from sandy loam to clay-heavy hardpan about 200 yards east of the old stock pond my grandfather had dug by hand with a borrowed excavator in 1952. I knew the cedar posts along the north boundary were set by my father and his brother the summer before my father left for college, and that some of them were still standing because the wood had been cut green and dried in place. I knew the deed was in a fireproof box in the back bedroom of the main house, along with the original survey plats, the title insurance policy, and every recorded instrument affecting the property going back to 1947. My father had kept them in order. I kept them in the same order. What I did not know, what I had not yet had reason to examine, was what had been happening at the spring for the better part of a decade. The Clearwater Ridge Community Association had been organized in 2009 when a development company called Meridian Land Partners began platting a residential subdivision on what had once been an adjacent ranching property to the south. The development sat entirely on land that Meridian had purchased and subdivided legally. My property and theirs shared a boundary along the southern fence line, a line surveyed in 1968 and recorded with precision. The boundary was not ambiguous. It was a line on a map that existed in the public record, and it had not moved. What had moved, apparently, was the association's understanding of where that line was. The letter in the manila envelope was not the first communication I had received from Clearwater Ridge. There had been two others in the months following my father's death, one regarding what the association described as an unmaintained access road that crossed, in their estimation, into a community buffer zone, and another regarding the spring which they characterized as a shared natural resource subject to community stewardship guidelines. I had read both letters carefully. I had noted that neither cited a recorded easement, a plat covenant, a county ordinance, or any other legal instrument establishing the association's authority over any portion of my land. I had filed both letters in a manila folder labeled Clearwater Ridge and placed it in the drawer below the fireproof box. I had not responded. The woman in the slate blazer, her name, as printed on the laminated badge, was Renata Collier, Director of Community Standards, had now delivered a third letter, this one escalating the language from guidance to enforcement. The spring access, she had said, unauthorized. 14 days. I read the letter that evening at the kitchen table, under the same overhead light my father had read his correspondence under for 30 years. It referenced a community resources management policy adopted by the association board in 2016. It described the spring as falling within a designated community watershed area. It cited a stewardship authority the board had apparently granted itself by internal resolution. What it did not cite, what it could not cite, because it did not exist, was any recorded instrument conveying to the Clearwater Ridge Community Association any legal interest in the spring, the surrounding land, or the access corridor leading to it. I set the letter down. On a yellow legal pad, I wrote 3 words: survey, deed, records. Then I made a phone call to a land attorney in Boise named Gerald Fitch, who had handled my father's estate and who had the particular quality I value most in professionals. He did not speak until he had something to say. Gerald's first question was whether I had a current survey. I told him I had the 1968 survey and a partial update from 1991. He said we would need a new one, a full boundary survey with GPS-verified monuments filed with the county. I told him to arrange it. He said the surveyor could be on site within 2 weeks. I told him that was fine. I was not in a hurry. The land had been there for a long time. It would wait. The survey crew arrived on a Tuesday, 3 men with equipment I recognized from my engineering work. Total stations, GPS receivers, data collectors that would cross-reference every point against the county's recorded plat coordinates. They spent 4 days on the property, working from the established monuments outward. I walked portions of the boundary with them on the 2nd and 3rd days, not to direct them but to listen. The lead surveyor, a compact and methodical man named Dale Pruitt, had been doing boundary work in eastern Oregon for 22 years. He did not offer opinions easily. On the afternoon of the 3rd day, standing at the southwest corner monument, a rebar pin set in concrete that my grandfather had placed in 1968 and that Dale's instruments confirmed had not moved a fraction of an inch, Dale looked at his data collector screen, then looked at the terrain to the south, and said quietly, "Your boundary runs about 240 feet further south than what they've been treating as the line." I looked where he was looking. 240 feet south of where we were standing, just visible through the scrub juniper, was the roof of the association's maintenance facility. I did not say anything for a moment. The wind moved through the juniper. A hawk turned slow circles above the ridge. "How confident are you in that?" I asked. Dale looked at his screen again. "The monuments are original and undisturbed. The legal description is unambiguous. I'm as confident as I get." That was the first number I wrote on the legal pad when I got back to the house, 240 feet. Then I sat down with the deed, the original survey plats, and the county assessor's parcel map I had requested from the Malheur County offices the previous week, and I began to read everything in the order it had been created, slowly, checking each element against the requirement it was supposed to satisfy. The assessor's map showed the association's maintenance facility parcel as a separately assessed lot, number 7-114-0032, with a listed owner of Clearwater Ridge Community Association and an assessed value of $214,000. The parcel had been created in 2011 by a lot line adjustment recorded by Meridian Land Partners. I pulled the lot line adjustment document from the county recorder's online database. It described the adjustment as a minor boundary modification to accommodate community infrastructure. What it did not include was any signature, consent, or acknowledgement from the owner of the adjoining parcel to the north. The parcel that, according to Dale Pruitt's survey and the original 1968 legal description, extended 240 feet further south than the line Meridian had drawn. The adjoining parcel to the north was mine. The lot line adjustment had been recorded as if my father's land did not exist, or as if the line between his land and theirs was a matter of administrative preference rather than a recorded legal instrument. My father had been alive and in full possession of the property in 2011. No one had asked him anything. I added a second line to the legal pad. Then I called Gerald Fitch. He was quiet for a long moment after I finished reading him the relevant sections. Then he said, "Elias, I think we need to pull everything. Every recorded instrument, touching that boundary, going back to the original deed." I told him I had already started. The documents came in over the following days. Scanned PDFs from the county recorder's office, printed copies from the state land board, a certified copy of the original 1947 deed, recorded in a hand so deliberate it looked almost typeset. I spread them across the kitchen table in chronological order and worked through them the way I had learned to work through engineering drawings, systematically, without assumption, checking each reference against the instrument it was supposed to derive from. The chain of title was clean from 1947 through 2011. Then came the lot line adjustment, and the chain broke. Not dramatically, not in a way that would have been obvious to a casual reader, but cleanly and completely. Meridian had moved a line that was not theirs to move, and in doing so had placed the association's maintenance facility, its access road, and the 40-foot corridor leading to the spring on land that belonged to my family. Gerald filed a quiet title action in Malheur County Circuit Court in the name of the Voss Family Trust on a Wednesday morning. The complaint was 41 pages. It attached the original deed, the 1968 survey, Dale Pruitt's new survey report, the lot line adjustment document, the assessor's parcel map, and a legal memorandum arguing that the 2011 lot line adjustment was void ab initio, void from the beginning, because it had been executed without the consent of the adjoining landowner as required under Oregon Revised Statutes, Section 92.192. The memorandum cited 3 Oregon Court of Appeals decisions. It was, Gerald told me, as clean a quiet title case as he had prepared in 20 years of practice. Renata Collier did not know any of this yet. She was still operating under the assumption that the boundary was where Meridian had drawn it, that the spring was a community resource, and that I was a non-compliant property owner with 14 days to correct my behavior. She had sent a follow-up letter the week after her visit, referencing the association's legal authority to pursue injunctive relief if I continued to access the spring corridor. I logged it and filed it in the Clearwater Ridge folder without responding. There was something I had not yet told Gerald because I had only recently begun to understand its dimensions. It had started with a question that occurred to me while reviewing the assessor's records. If the association believed the spring was within their community watershed area, what exactly had they been doing with it? I drove out to the western edge of the property on a clear morning, following the old 2-track along the limestone shelf. The spring emerged from the rock face the way it always had, quietly, without announcement, a thin sheet of water spreading across pale stone before gathering into the small pool my grandfather had lined with flat river rock. But there was something new near the pool. something that had not been there when my father was alive. Pipe fittings in the rock, steel galvanized, threaded into a coupling mortared into the stone face below the main emergence point. A half-inch line ran from the fitting along the ground under a shallow trench that had been cut and backfilled. The trench ran south toward the maintenance facility. I followed it with my eyes as far as I could see. Then I took out my phone and photographed everything, slowly and completely, the way my father had taught me to document anything that might later need to be explained. I did not yet know where the line went, but I knew what a water extraction fitting looked like, and I knew that no one had asked my permission to install one. Gerald called me on a Thursday morning, 2 weeks after filing the quiet title action, his voice carrying the careful stillness of a man who has picked up a rock and found more underneath it than he had anticipated. "I've been running the chain of title on the access road," he said, "the one she drove in on when she delivered the letter. There is no recorded easement, not in 2009 when the association formed, not in 2011 when Meridian did the lot line adjustment, not at any point in the recorded instruments touching your parcel. They have been using a road on your land under the apparent belief that the road was either on their land or on land to which they had some right of access. Neither of those things is true." I wrote the words access road, no easement on the legal pad, and underlined them once. I asked Gerald what that meant procedurally. "It means we amend the complaint. We add a claim for trespass by continuous use and a request for injunctive relief. We also add a claim for unjust enrichment, because they have been deriving a benefit, road access to their maintenance facility, from your property without compensation. The grading permit was pulled in March of 2012. The county has it on file. Meridian's contractor pulled it under the representation that the road was on association property. That representation was false." I told Gerald to amend the complaint and add whatever claims the facts supported. Before he hung up, he said, almost as an aside, "Elias, the association has retained counsel, a firm out of Bend. I received a letter yesterday requesting a 30-day extension to respond to the original complaint." I asked him what he had said. "I said no," Gerald said, courteously. The amended complaint ran to 57 pages and attached, in addition to the original exhibits, the grading permit from March 2012, Dale Pruitt's declaration establishing that the access road lay entirely within the Voss family trust parcel, and a damages calculation estimating the fair rental value of the road corridor at $11,400 per year, derived from comparable easement agreements recorded in Malheur and Harney counties. The total from March 2012 through the date of filing was $137,000. I did not arrive at that number with any particular feeling. It was simply what the arithmetic produced when you applied a fair rate to an established period of use. The association's attorney, a man named Caldwell from the Bend firm, filed a motion to dismiss. The motion argued that the 2011 lot line adjustment carried a presumption of validity as a recorded instrument, and that the association's use of the access road for more than 10 years might give rise to a prescriptive easement claim. The prescriptive easement argument was the only one that required any thought, because Oregon law does recognize that a party who uses another's land openly and continuously for 10 years may acquire a right to continue that use. But the argument had a problem. A prescriptive easement cannot ripen against a landowner who has given permission for the use, because the element of adversity is defeated by consent. More to the point, Meridian had represented to the county in the 2012 grading permit application that the road was on association property. That representation, Gerald argued in his response brief, constituted a claim of ownership rather than a claim of easement. You cannot simultaneously claim to own land and claim a prescriptive right to use it. The two theories are mutually exclusive, and the association, by virtue of its predecessor's representations, was estopped from asserting the lesser right after the greater one had failed. Gerald's response brief was 23 pages. It cited 7 Oregon cases, 2 Oregon statutes, and 1 restatement of property section. I read it twice and thought that my father would have appreciated its precision. He had always said that the most powerful thing a man could bring to a dispute was a clear record and the patience to let it speak. What the motion to dismiss did not address, what Caldwell's brief did not mention at all, was the water fitting, the pipe in the rock face. I had not yet raised it in the litigation. I had photographed it, measured it, and noted it in my records, and I had asked Gerald to hold it. Not because it was unimportant, because I did not yet know what it was connected to, and I had learned from my engineering work that you do not present a finding until you understand it completely. I understood it better now. A neighbor of mine, a man named Roy Akins, who ran cattle on a section of land to the east and who had lived in this part of the county his entire life, had mentioned something to me when I ran into him at the feed store in Vale. Roy was not a man who sought out conversation, but he had a habit of observing things carefully and filing them away. "Those Clearwater people have been hauling something out of there," he said, not looking up from the bag of mineral supplement he was examining. "Seen their trucks on your road 3-4 times a month for the better part of 3 years. White refrigerator trucks, not the maintenance rig, different trucks." I asked him what kind of trucks. "Insulated," he said. "The kind you use for product that needs to stay cold." He set the bag down and looked at me. "Thought you knew." I told him I was finding out. That evening I drove the 2-track out to the spring again in the last of the light, the high desert cooling fast around me the way it does in October. I stood at the rock face and looked at the fitting and the pipe and the shallow trench, and I thought about refrigerator trucks and cold product and a board that had granted itself stewardship authority over a spring it did not own. I walked the trench line south as far as the light allowed, about 300 yards, and noted where it disappeared under a section of chain-link fencing marking the perimeter of the association's maintenance facility compound. I did not cross the fence. What was on my side of it was already more than sufficient. I called Gerald the next morning and told him what Roy had said and what I had seen. There was a silence of the kind Gerald produced when he was thinking rather than when he had nothing to say. "If they have been extracting water from that spring for commercial purposes," he said, "that is not a trespass claim. That is a conversion claim, possibly a theft of natural resources claim under Oregon statute. And if they have been selling it, we are talking about unjust enrichment at a scale considerably larger than a road easement." I told him we needed to find out exactly what was at the other end of that pipe before we made any further filings. Gerald agreed. He said he would engage an investigator. I told him I had someone in mind, a former county assessor's office employee named Patricia Swan, who had a particular facility for finding things in public records that other people had overlooked. Gerald said to send him her contact information. Patricia called me 2 days later and said she had already started. She had found something in the Oregon Department of Agriculture's food processing facility registry that she wanted me to see before she said anything more. She would send it by email that afternoon. The document arrived at 4:17. It was a food processing facility registration issued by the Oregon Department of Agriculture under ORS Chapter 616 for a facility described as a small-scale bottled water operation. The registered business name was Clearwater Ridge Pure Spring Water, LLC. The registered address was the association's maintenance facility on Lot 7-114-0032. The registration had been issued in 2019 and renewed annually through the current year. The listed owner of the LLC was the Clearwater Ridge Community Association. I set my phone down on the kitchen table, next to the legal pad and the stack of county records and the fireproof box that held my grandfather's deed. The overhead light hummed. Outside, the wind had come up along the ridge, moving through the juniper with a sound like water over stone. They had been bottling the water from the patient's spring, from the seam of limestone that August Voss had found in 1947 and that had been pushing water to the surface at exactly the rate the earth allowed, and they had been selling it under a registered business name, with a state-issued food processing license, for at least 4 years, and possibly longer if the extraction had preceded the formal registration. They had done all of this on land they did not own, drawing water from a spring they had no legal right to touch, and they had dressed the operation in the language of community stewardship and watershed management, and they had sent Renata Collier to my driveway in a slate Blazer to tell me that my access to it was unauthorized. I was not angry. I want to be clear about that. What I felt was closer to the sensation of a long equation finally resolving. All the terms present, all the relationships established, The answer sitting there on the page with the quiet certainty of something that was always going to be true. I picked up the legal pad. Below the 2 lines already written there, I added a third. Clearwater Ridge Pure Spring Water, LLC, ODA Registration 2019, Bottled Water, Patient Spring. Then I drew a line under all 3 entries and wrote in the margin the word Gerald. He answered on the second ring. I read him the registration document. He did not say anything for a long moment. Then he said, in the careful, measured tone he used when the facts had exceeded even his expectations, "Elias, we are going to need to amend the complaint again." I told him I had expected as much. "And," he said, "we are going to need to calculate damages on a different scale entirely. If they have been selling water commercially from a spring on your land, we are looking at conversion of a natural resource, unjust enrichment measured by their revenues, and potentially a claim under Oregon's Unlawful Trade Practices Statute, which carries its own fee-shifting provision. We will need to subpoena the LLC's financial documents." I told him to do whatever the case required. "One more thing," Gerald said. "The fact that they registered this business with the state under a name that includes the words spring water and renewed that registration annually, that is not going to help them argue that they didn't know what they were doing." I told him I thought that was probably right. The second amended complaint was filed on a Thursday morning in Malheur County Circuit Court, and it was 69 pages long. Gerald had organized the claims in 4 counts. The first was the quiet title action, unchanged. The 2011 lot line adjustment was void ab initio, and the association's maintenance facility, access road, and spring corridor were on land belonging to the Voss Family Trust. The second count was trespass and unjust enrichment for the access road, with damages calculated from March 2012. The third count was conversion of a natural resource, the water itself, drawn from the spring without authorization, without compensation, and without any recorded legal right. The fourth count was a claim under Oregon's Unlawful Trade Practices Act because the association had registered a commercial business and operated it on the basis of a resource they did not own, which met the statutory definition with sufficient precision to warrant the claim and its attendant fee-shifting provision. The damages figure in the third count required the most explanation when Patricia Swan delivered her full research report. She had found the LLC's annual reports filed with the Oregon Secretary of State's office, which listed gross revenue figures for each year of operation. Over 4 years of documented operation, Clearwater Ridge Pure Spring Water, LLC, had generated revenues totaling just under $380,000. Patricia had also found 2 years of prior extraction records in the association's own board meeting minutes, located in the County Planning Department's file on the Maintenance Facilities Conditional Use Permit. The minutes referenced the Springwater program as an association revenue initiative beginning in 2017, 2 years before the formal LLC registration. Gerald added those 2 years to the damages calculation at an estimated rate derived from the documented years, and the total conversion damages figure, before any multiplier, was $460,000. I wrote that number on the legal pad and looked at it for a while. Then I thought about Renata Collier standing at the edge of my gravel drive, telling me that my access to the spring was unauthorized. I thought about how a word can be borrowed from a legitimate context and applied to an illegitimate one, and how the borrowing works only as long as no one checks the underlying record. She had been standing on my land when she said it. She had driven in on my road. She had been, at that moment, the representative of an organization that had been extracting water from my spring, bottling it under a registered trade name, and selling it to grocery stores, and she had delivered a letter informing me that I was the one in violation. That is, technically speaking, one of the more remarkable moments I have encountered in a long acquaintance with property disputes. The hearing on the motion to dismiss was set for a Tuesday in October in the county courthouse in Vail. I drove there in the same truck I used to check fence line, which seemed appropriate. Caldwell argued first, a composed man, well-dressed with the practiced cadence of someone accustomed to making arguments in unfamiliar courtrooms. He led with the presumption of validity that attaches to a recorded instrument, spent considerable time on the prescriptive easement argument, and cited the 10-year period of open, continuous use. He did not mention the water. He did not mention Clearwater Ridge Pure Spring Water, LLC. He argued as if the case were about a road and a boundary line, and nothing more. Gerald argued second. He was shorter, quieter, and considerably more precise. He walked Judge Eckert, a methodical woman who had been on the Malheur County bench for 11 years, and who Gerald described as someone who read every page of every brief before she took the bench, through the chain of title from 1947 to 2011, citing each instrument by recording number and date. He placed Dale Pruitt's survey report before the court as Exhibit A. He cited Oregon Revised Statutes, Section 92.192, and the 3 Court of Appeals decisions he had included in the original memorandum. He addressed the prescriptive easement argument in 4 sentences, citing the estoppel doctrine and the mutual exclusivity of an ownership claim and an easement claim. Then he said quietly that the court might also wish to consider the broader context of the association's activities on the disputed parcel, at which point he introduced the ODA registration, the Secretary of State's annual reports, and the board meeting minutes as Exhibits B, C, and D. The courtroom was not large, but I watched Caldwell's posture change when Gerald placed those 3 exhibits before the court. It was a small change, a slight forward lean that reversed itself, a stillness that replaced the practiced ease of his earlier presentation. He had not known about the water operation, or if he had known, he had not known that we knew, and he had not known that it was in the record. Judge Eckert denied the motion to dismiss from the bench. She said the quiet title claim was sufficiently pled, and that the recorded instrument presumption did not overcome the statutory consent requirement cited in the complaint. She said the prescriptive easement argument was not ripe for resolution on a motion to dismiss and would require a full evidentiary record. She said the conversion and trade practices claims were adequately supported by the exhibits. She ordered the case to proceed to discovery. That was all she said. It was enough. The discovery period lasted 4 months. Gerald subpoenaed the LLC's financial records, its banking documents, its supplier agreements, and its distribution contracts. The association's counsel produced them under protest and with a motion for a protective order that Judge Eckert denied. The records confirmed what Patricia's research had suggested and added detail that neither of us had anticipated. The association's board had voted, in a closed session in March of 2018, the minutes of which were among the subpoenaed documents, to treat the spring water revenues as a restricted reserve fund to offset association operating costs. The vote had been unanimous. All 5 board members, including Renata Collier, who had been elected to the board in January of 2018, were named in the subpoenaed minutes. The case settled before trial. I want to be precise about that, because the settlement was not a compromise in the sense of each side receiving less than it wanted. It was a resolution in which the record had already determined the outcome, and the settlement was simply the mechanism by which that outcome was formalized without the additional expense of a trial neither side needed. The terms were as follows. The 2011 lot line adjustment was vacated by stipulated court order, restoring the boundary to the line established by the 1968 survey and confirmed by Dale Pruitt's current survey. The association's maintenance facility was confirmed to sit on Voss Family Trust land, and the association was given 18 months to relocate it or negotiate a lease at fair market value. The access road damages were paid in full, $137,000. The conversion claim for the spring water operation was resolved by a payment of $390,000, representing the documented revenues adjusted for the pre-registration period and a negotiated figure for the 2 prior years of estimated extraction. The LLC was dissolved as a condition of settlement. The water fittings and the pipe were removed from the spring face and the trench backfilled, and I watched the crew do it on a cold morning in February, standing at the rock face with my hands in my coat pockets while they worked. The total payment to the Voss Family Trust, including attorney's fees under the trade practices fee-shifting provision, was $562,000. Gerald said it was the largest property settlement he had handled in Malheur County. I told him that was not why I had pursued it. It was not. I had pursued it because the record required it, and because my grandfather had taught me, by example rather than instruction, that the way you treat land that has been entrusted to you is the way you treat the trust itself, with precision, with patience, and without the assumption that silence is the same as consent. The board of the Clearwater Ridge Community Association did not survive the settlement. 3 of the 5 members, including Renata Collier, resigned before the ink was dry on the court order. The other 2 declined to stand for re-election at the association's annual meeting the following spring. The new board sent me a letter in April, not a certified letter with a seal and an enforcement timeline, but a plain letter on plain stationery, signed by the new president, a retired schoolteacher named Margaret Hollis, who said that the association wished to begin the relationship between their community and my property on a different basis than it had previously been conducted. I wrote back and said I appreciated the sentiment and that I was available to discuss any matter that concerned our shared boundary, provided it was grounded in the recorded instruments. Margaret Hollis wrote back and said that seemed entirely reasonable. We have not had a dispute since. There is a principle underneath all of this that I think about when I walk the western edge of the property in the mornings, following the old 2-track along the limestone shelf, listening to the spring move across its pale stone the way it has always moved, at exactly the rate the earth allows, without hurry, without announcement. The principle is this: when an institution with apparent authority makes a claim against you, the first question is not whether the institution is large or organized or capable of enforcement action. The first question is whether the claim has a legal foundation. And the answer to that question is never in the institution's letterhead, never in the laminated badge, or the slate blazer, or the rehearsed forward lean of the person delivering the letter. The answer is in the record. It is in the deed filed at the county seat, in the survey monument set in concrete, in the chain of title that runs from the first instrument to the last without a break. The record does not raise its voice. It does not need to. The spring is still there. The water still comes up through the limestone seam at the same rate it has since my grandfather first found it in the fall of 1947 and named it for the quality he admired most. The pipe fittings are gone, the trench is filled, the rock face is clean. On a clear morning, with the high desert light coming in low from the east and the juniper casting long shadows across the pale ground, you would not know anything had ever been different. That is, I think, the way my grandfather would have wanted it. He was a man who respected things that did not hurry, and he understood that the land remembers what we sometimes forget, that what is earned and recorded and tended with patience will outlast anything that is merely assumed. If you have a story about a boundary dispute, an HOA overreach, or land that has been in your family long enough to feel like something more than property, I would like to hear it in the comments. And if you want to follow the next case, because there is always a next case, and the next one involves a dam, a downstream neighbor, and a water rights claim that goes back to 1931, consider subscribing.